Thank you everyone for joining today's knowledge sharing webinar. My name is Alex from LexisNexis. I will be the MC for today. Today's webinar's topic will be on estate planning to avoid family disputes, and we're very honored to have two established speakers and practitioners on wills and probate law to join us here today. On the left, we have Mr. Alfred Ip, partner of Hugill Ip solicitors, and on the right, you'll see Mr. Kerby Lau, Barrister-at-law of Voeux Chambers. So please feel free to let us know if you have any questions. You can, of course, type them out in the chat box below, either in public, or you can transfer them over to the LexisNexis Hong Kong account privately. But yeah, without further ado, please welcome Alfred and Kerby. Thank you.
Thank you. Perhaps I should start because I am usually instructing. Of course. And you are the one who will be arguing. And a lot of time, we only come to you when family are in dispute. So yes. Sometimes it's a bit too late. Yes. Yeah. But yes, we are on the planning side. So part of the purpose of this seminar today is how to avoid those conflicts with looking at what usually are argued about at the High Court. Yes. Yeah. So today we are going to cover 3 topics, right? Yes. Yes. And yeah. So the first part will be the importance of estate planning, because a lot of people do not have planning. Yes. They don't understand the importance of planning. Yeah. And they thought that after they passed away, everything would just come into place. Yeah. Yeah, and that is one of the major problems when suddenly, especially when it's sudden death, everything just fall into everywhere, yes. and it's become a mess. It's basically that is the problem that a lot of people do have. Yeah, so perhaps what we can talk about is the first slide. The first slide will be about the importance of estate planning. Yeah, so a lot of people, first of all, would not plan about that. Or you would agree with me?
I definitely agree, yeah, especially in Hong Kong.
Yeah, and especially when there's no incentive for them to plan about that. It's not like a lot of other countries when there are a lot of tax involved in that people must have a good estate planning in place in order to save tax. Hong Kong, there's no such things, and people may think that, oh, after they passed away, there will be the intestacy rules. People would just assume the position and administer the estate, without thinking that actually there could be a lot of problems. Especially when we're talking about there are vulnerable family members. For example, young children, and then second of all, the elderly parents, and then disabled person. And in that respect, perhaps I can share with you that under the intestacy rules, especially in terms of the probate, non-contentious probate rules, when there are minor interests involved, that is beneficiaries who are under the age of 18, there has to be 2 administrators. And of course, under the contentious probate rules, when there's no will in place, there are a certain level of categories of family members who have the priorities in administering the estate. And talking about, for example, a very typical nucleus family with young children, so there is husband and wife, and then for a couple of young children, when suddenly there's one parent who passed away, the remaining parent will have to be the administrator of the estate, and the parent would have, under the intestacy rules, the first 500,000 as of the fixed gift, and then half of the estate, with the rest to be shared among children in equal shares. But then the problem lies when there are minor children and they are the beneficiary of the estate, that it is required that 2 administrators have to be appointed to administer the estate. And when there's only one parent that is surviving, who will be the next person who is going to be the administrator to co-administer the estate with the surviving spouse? So that will come with a lot of problems, especially when, for example, the next in line will be the deceased parents, who will be the grandparents of the young children. But what if they're not in harmony, in good relationship with the surviving spouse? And in particular, a lot of time there are a lot of dispute among the first generation, second generation, a lot of jealousy and all this. Alternatively, the parent would nominate another person to be the co-administrator instead of the parent of the deceased. But then the probate registry would certainly ask, why would that person be nominated instead of another person? And that would be that would definitely delay the process in administering the estate. And all this can be avoided with a very simple will. A lot of time we do have client coming to us and we say, what is your wishes? You have your spouse, you have young children. And they say, oh, I'll just leave it to my young spouse. And if my spouse passed away before me, I'll leave it to my children. It sounds very natural, but without a simple will in place, that will not happen. So that will highlight the importance for young family to have a will in place, even though they never thought about death, they never thought about retirement, and they don't think death is imminent. But that is actually the fact that it's important to have the will in place in order to avoid any argument between family members over who should administer the estate. The same would apply to elderly parents, especially when we are talking about elderly parents who may not be very smart in administering the estate and receiving the inheritance. A lot of time, elderly parents do become vulnerable. They are susceptible to people that are close to them. And in that respect, I'm not sure if I'm doing this case with you, but then there was elderly parents or elderly people who become the victim. They may ask to sign documents, to transfer anything that they have to anyone, or they become paranoid. A lot of time, actually, they do not know, or family members would not know whether they still have the mental capacity. And with the age that is going to, with the longevity of life of the average population, there are more and more people who may become of an advanced age, who may lose the mental capacity. They become they suffer from dementia or other problem that they don't know how to protect their own assets anymore. And that is for that reason, leaving them your estate or letting them administer the estate may not be the best idea. And that is a lot of time, a lot of problem involved when there's this problem and the second generation were trying to protect the first generation against anyone trying to take away their assets. And that would involve a committee application, we call it, basically a court order to take over the financial power of a vulnerable person. But that would definitely involve at least two psychiatrists who will be filling in a form to testify that the patient has lost mental capacity. And in our experience, a lot of time, getting those two psychiatrists to visit the patient, to administer a mental test and testify that the patient has lost mental capacity is becoming itself a very tricky question, very tricky problem. So usually the planning part would be to have the enduring power of attorney. But then enduring power of attorney, it was a little bit unpopular in the past because of the onerous requirements for the for it to be attested with one doctor and one lawyer. And now people seem to be more accepting towards the use of the EPOA. But that would require planning. My point, that is will require planning. This is the reason why it's important to have your the affair in place. And similarly for the disabled person, if they cannot look after the wealth, who will look after the wealth for them? And especially for those who cannot manage their affairs, like those who are mentally, we call it challenged. Yeah, in the American way, mentally challenged, or they require constant care. Sometimes I know that nowadays it's relatively easier to manage your own affairs, especially in terms of banking affairs. All you have to do is to log in online and do a lot of things. But for a lot of people, if they cannot manage their own life on a daily basis, how can they manage their affairs? Yeah. So that is, I think that is the importance of having planning in place. And perhaps the next step that we need to talk about is the probate process. We did mention something about the probate process, about, for example, applying for the grant. That is the part that we will come across a lot of time. When a family member passed away, especially when there's no will, the family members, to take over the succession process, will have to prove that they are entitled to the grant. And in that respect, to prove the entitlement, of course, that would require them to produce sufficient document to prove their relationship with the deceased. And proving the relationship with the deceased, sometimes a lot of people would automatically assume that it is a relatively straightforward process. If you're the spouse, produce the marriage certificate. If you're the son, produce the birth certificate. Easy. But then, going back to what I said earlier in relation to the probate process, there's a priority of people who are entitled to administer the estate. And by having priority, that means that those who are in priority must be cleared off before the person next in line will be entitled to the estate, to administer the estate. For example, in the intestacy, when one person passed away, the first person in line would be the spouse, and the second person in line would be the children. If the spouse has already passed away, of course, the children who want to administer the estate have to prove that the spouse has passed away. And then we will be involved in producing the death certificate of the spouse, and of course the marriage certificate to prove that they two are married, and then to produce the birth certificate that is to prove that he's the son of the deceased, and that means marriage certificate, death certificate, birth certificate, 3 certificates. And all these are well and good if the deceased died in Hong Kong and they are in Hong Kong all his life. Everything is really issued by the authorities in Hong Kong, birth and death registry and the marriage registry. But if any of them married or gave birth in the other countries, authentication become a very, very serious problem. Yeah. Authentication means that the person who produces the documents must show that the document is genuine. And in that respect, a copy produced by the notary public is simply not enough. And it has to be authenticated by the relevant authority. In the Hague Convention countries, all they have to do is to get the document apostilled, direct apostille. But there are countries that are not Hague Convention countries. And one of them, for example, is Canada. Canada is particularly complicated because it's a very big country in the first place. And then all the documents have to be legalized by the Chinese consulate. And then because there are so many provinces in Canada, different provinces, different Chinese consulate may have different requirements about whether to legalize a document and how to legalize it. Some require a notary public, some don't. Some only legalize document in Chinese, some don't. If it's in French, it may have to be translated. It's all become a very painful process. And again, all this can be avoided if with one word, appointing the person who will administer the estate with the proper identification, such as Hong Kong ID card, or passport number, or address, or a description of the relationship. So all these are things that our client would generally not think about, but would come to us and we will explain to them the difficulties if there's no will in place. And that is the problem when people don't think about it and thinking that everything will fall into place. And of course, Another problem that some people would not think about is, for example, if that person is not a Hong Kong person, he's an expat, who may be living, only living in Hong Kong for a temporary period of time. And that will come to the issue of domicile, when the person may be domiciled in other countries and the succession law will be governed by the law of that country. And a lot of the time, it is actually very difficult to produce a affidavit of foreign law to prove that the person who applied for the grant actually has the authority to administer the estate, simply because, for example, they are from a civil law country when there's no such thing as administrator being appointed. And in that case, a lot of time in the civil law countries, the family actually goes before notary public and apply for a succession, and the notary will issue a succession certificate to confirm that those are the heirs of the deceased who are entitled to share the estate, and they will bring the the succession certificate to the relevant authorities or the banking institutions to close the account or apply for transfer of ownership of property. And all these are very different from the Hong Kong system when one person is going to be appointed to administer the estate. And that presents the problem which complicates the application for grant, especially when a lot of civil law countries do not have a resealing arrangement with Hong Kong, that any of those certificates can be easily resealed in Hong Kong, leading to a complication of the process. And that I have been talking non-stop, but the only thing that I want to cover very, very briefly is in relation to the tax. UK, US, and Canada are notorious with tax.
Yeah.
And a lot of time people don't know that, well, after they passed away, the state may have to pay a lot of tax. For example, UK tax, after the new rate of £325,000, there will be other inheritance tax of 40%. Canada, there's no estate duty, but then there's the probate fees, and then we call it the capital gain tax. They are all not advised. But then the problem with those taxes is that with the liability of paying the tax, a lot of assets under the estate may not be may have to be liquidated in order to pay for those taxes. A lot of people do want the family members to keep the family wealth in a certain form, for example, the family home. But a lot of the heirs may not be able to do that when there's such a hefty tax bill that they have to pay before they can inherit the estate. And that's the problem that a lot of time is presented. So yes, and let me see. All these require some foreign tax advice, and the next thing I want to talk about is the potential consequences of no estate planning. Yes, we can you can move to the next slide. Earlier we did talk about this priority in administration of the estate, and in that respect, can you share with us? Let's say, for example, there's a family members who wants to administer the estate, but I have a problem trusting him or her.
Yes. No, I'll be definitely happy to. And now, what Alfred, you have just very helpfully gone over is the importance of estate planning, and certainly, issues and procedural issues that will be encountered without a will, without proper estate planning, just in the ordinary course of events or in the non-contentious sense. The second and the third subtopic that we actually will be briefly discussing today actually relates to the consequences of no estate planning and the consequences of poor estate planning. And the two it's actually quite an interesting distinction. It's a quite interesting comparison when I was presented with the topic, because certainly when we are dealing with a situation where there is no estate planning, right, it's quite natural, because in that sense, what actually happens is that the deceased or the passed away, his wishes well, will not be considered, right? So naturally, there will be a lot of disappointment, dashed expectations, and therefore one could see naturally that will lead to quite a bit of uncertainty and dispute. But when we're talking about, what is perhaps less obvious is that it's probably the other situation where there is poor estate planning, where there is actually even more dispute. That's a scenario which is even more prone to dispute. And because while where there's no estate planning, right, that what will happen is the testamentary rules will apply. So at least we know what the rules are, even though there may be disputes and uncertainty when you apply the rules to the facts. But when we're dealing with a situation where there's poor estate planning, what you actually get is oftentimes a lot of speculation as to the testator's intentions, a lot of speculation and actually support for conflicting and contrary version of events. And therefore, that actually just leads to uncertainty as to what rules ought to be applied. So going first of all into consequences of no estate planning, Alfred has very helpfully basically just gone through the priority, and it's also on the slide, which is in the first part. Going on then to the disputes that will often arise. Now, when we're talking about grant of administration, and certainly in the intestate estate situation, disputes often arise in two forms, right? It's either where there is dispute as to whether a person who is entitled in priority to the grant ought to be given the grant, or the second type of dispute is whether candidates in the same priority entitled to the grant in the same degree ought to be given the grant. And in these situations where there are such disputes, what actually happens is that the court will then have to exercise its discretion, which is under Section 36 of the Probate Administration Ordinance or Rule 25 of the NCPR, to make a discretionary grant. And the key considerations is basically whose appointment, so appointing which candidate, would actually be in the best interest of the estate, as well as whose appointment would actually lead to the most expeditious and economic administration of the estate. And just a side point here, best interest of the estate, the court has actually held, does not actually always equate with the interest of beneficiaries. Right? Sometimes it also includes the interests of all the other stakeholders, including creditors. And this point will, of course, be prominent where the estate actually has a lot of debts or where it's actually insolvent. So when making a discretionary grant, the court, just to break it down, essentially looks at three key criteria. The first is the ability of the candidate to actually administer the estate according to law, according to rules. Second is the speed of administration. Third is, of course, the cost involved in administration. And because this is a discretionary grant, and that brings us back to the main topic of today, because it's discretionary, ultimately there will be uncertainty, there will be disputes in the application of the rules. And all these problems can actually go away if there is actually proper will and proper estate planning. So very quickly, we can go into, just to give a flavor of the nature of disputes and how it can get quite messy at times. Now, there are numerous factors that will actually affect the court's consideration of whether the three criteria we just said, which is administering estate according to rules, speed, and cost, whether the three criteria are actually fulfilled. And amongst them, these factors were based on the authorities, a lot of which Alfred and I were actually involved in. There seems to be three key factors which emerges as being the most common and being of the most weight. The first, as you can see on the slide, is intermeddling with assets of the estate or causing inexplicable diminution in assets of the estate. Now, the weight of such a factor is, of course, quite obvious. The administrator's role would be to collect and administer the assets. So if he has been proven inadequate in that regard in the past, naturally, the grant ought not to be made to him. And of course, there's also a separate problem, which is that if he had actually intermeddled or caused a diminution inexplicably of the assets, he will be subject to investigation and possibly claims, and therefore there could be a conflict of interest.
Post here,
yes.
A lot of people actually do not understand what's intermeddling.
Now, intermeddling, well, intermeddling actually means the interference with the assets of the estate prior to a grant that's actually being made. So to put it in a simpler sense, it's basically to interfere or deal with the assets of the estate without proper authority and without a proper legal basis.
A very common example in that
Yes.
sense would be safe deposit box.
Yes.
A lot of people do have joint safe deposit box
Yes,
with joint
definitely.
renter. One of the renter passed away, and the surviving renter may not know that actually they should not be going in to the box and remove any of the contents that may belong to the estate.
Yes.
And in that respect, the proper procedure would be to make an appointment with the Home Affairs Bureau in order to take the inventory.
Yes.
But then a lot of people do not know about it. They did go into the box and intermeddled before the inventory is taking place.
Okay.
And sometimes the Home Affairs Department would demand any explanation because there's record
Yes.
of people going in
Yeah.
after the deceased passed away.
Yes.
And that would lead into a lot of personal liability.
Yes. Yes. That is definitely one very common example which is often overlooked. And of course, the court really looks at the purpose of the intermeddling and whether or not there is good justification. So this is something that the court will definitely look at. And the second factor, which is also on the slide, is incompatible interest. Right? It's basically conflict of interest and or duties on the part of the candidate. And these would usually generally arise where there are claims by or against the estate with regard to this particular candidate, or where there are instances where the candidate has been enjoying the benefit of the property belonging to the estate, or using what we've just discussed in factor 1, which is basically where there has been intermeddling or inexplicable interference that may subject the candidate to a claim. Right? So these are common examples of incompatible interests. And to be more specific, sometimes you would see examples, and this again is quite often overlooked, which is a candidate that is occupying the property of the deceased without paying rent and has indicated an intention not to vacate property promptly. Now, in these circumstances, of course, there's a conflict of interest because he could delay administration for his own benefit. A second common situation, which is getting more and more common these days, is where there's a claim of constructive or resulting trust against the estate. Right? So the candidate may say that, there's a common understanding or agreement, or he has made financial contributions towards certain property that's registered under the name of the deceased and which he now has to claim for. So obviously in these cases, he shouldn't be made administrator, because otherwise, where he actually makes the claim for trust against the property, he will essentially be judged of his own cause. One scenario where the court has actually held that there's no conflict of interest which is also quite common, where the candidate has actually spent his own money for living or medical expenses of the deceased, and therefore has claims of reimbursement against the estate. Courts has generally held that these types are not really sufficiently serious to give rise to conflict, because it's just quite understandable that a close family members would be paying for the medical and living expenses of the deceased, and oftentimes these close family members would be amongst those with priority. Third factor, which is also on the slide, is residence outside Hong Kong. Now, this has both a practical and principal significance. Practically, you need to be in Hong Kong so that there can be expeditious and economic administration of the estate. But more importantly, in terms of principle, where you are appointed as administrator, you have to be subject to the supervision of the court, and therefore the person has to be in Hong Kong so that there can be personal jurisdiction over that particular person. And this factor is actually expressly set out in section 36 of the PAO itself. Right? So those are the three main factors. Ultimately, it will be a fact-sensitive question. So different combination of the different factors could actually apply with varying weight. And that is really one reason why there's quite a bit of uncertainty. And just as a matter of illustration in the slide, we've actually set out three different scenarios. So example, where we're talking about fights among siblings, they are of equal priority. So generally, the court will look first at which candidate has majority of support, failing which, the court will then look at whether or not there are the disentitling factors that we just discussed. And second scenarios where we are talking about a fight between, say, a spouse and the children, and oftentimes spouse and children of different marriages, so children of the first marriage plus a spouse against a spouse of the second or third marriage. The spouse, of course, will have priority, and as Alfred has said, a majority interest as well in the estate. So the burden is actually firmly on the children to say why that spouse is actually not appropriate to act as administrator. Now, the third scenario is where we have a contest between opposing independent administrator, and this is actually one of the most tricky situations where both sides actually propose an independent administrator rather than to propose themselves as administrator. And as Alfred and I will be aware, because we were both involved in one of the leading cases in this area, which is the case in the estate of LexisNexis. Right? Okay.
It's become a leading authority.
Yes, it is. In fact, in this area, because where the court actually dealt with proposal, in this case, our team was actually proposing Alfred to be the candidate, and it was successful. And what that case actually sets down is that this entitling factors, such as conflict of interest or inexplicable intermeddling of assets by the candidates, the family members themselves, actually play less of a role. Right? It's actually of relatively lower weight, and the reason being because in those situations, the family members, they are not proposing themselves to be the administrator; they're proposing independent candidate. And the court would generally assume that the independent candidate, professional candidate, will be independent, right? So it would not be affected by whatever wrong or misconduct that the family members themselves have carried out. Rather, the court will actually look at two main factors. The first is cost. So in this regard, cost cap and clear table of fees is very important. And the second is the certainty of cost, meaning whether the cost estimates are realistic and will not be prone to change, right? So this is actually as important, if not more important, than having a clear cost cap and table of fees. Sometimes the competence, the nature of the candidate and expertise of the candidate is also important. So sometimes an accountant may be suitable, other times a solicitor may be suitable, depending on the issues and disputes that can actually arise.
But it's very fact sensitive, isn't it?
It is definitely quite fact sensitive. So again, this is another reason why there is actually quite a bit of leeway for disputes. So then moving on to the third point on the slide, which is what happens after administration has been granted. So administrator, assuming administrator has now been appointed. Now, oftentimes people think that's the end of matters. So the party who's lost feel devastated, and the party who's won thing that they want everything and control. In reality, however, as Alfred and I would know, getting the administration is really but perhaps the end of the beginning, because it's upon the appointment that the real work really starts. So once administrator is appointed, administrator must start work collecting in and preserving the assets, discharging liabilities, preparing assets for distribution. So assets that can be sold, they should be sold, which are in the possession of others, they ought to be recovered. Assets which cannot be immediately sold, they will have to be rented out or used to generate income. And of course, amidst all this, the administrator must also keep a true and perfect inventory and account of the entire administration. So it's really a very tedious and time-consuming process, and it's really, unsurprisingly, a process where a lot of things can go wrong, and therefore disputes oftentimes arise after a grant has been made. And therefore, in those situations, beneficiaries will either seek an account, or, which is getting more and more common these days, to actually seek removal of the administrator that has been appointed. The general principles that are actually applicable when we deal with disputes on removal is actually quite similar to what we're talking about regarding the discretionary grant. There are a few differences, however, and we can perhaps just very briefly go through a couple of these. The first is, of course, in terms of threshold. The threshold where we're dealing with removal is definitely higher than when we're dealing with discretionary grants. So the courts have actually observed that the removal power should be exercised quite cautiously and sparingly. And it's not enough simply to say that another candidate can do the job better, right? Because this approach to say that another candidate will be better, this is generally sufficient when we're dealing with discretionary grants. But we're talking about removal, this is actually not sufficient. Courts will be quite willing to give the incumbent administrator another chance, if the mistake or whatever error that's being complained of was actually inadvertent or was a relatively minor slip that can be rectified. The second, of course, is that having said that, following from this first point, although the threshold may be higher, in practice, because the administrator has been in administration for usually a while, so he has had opportunity to prove himself, and in disputed cases, often to prove himself unsuitable for the job. So in practice, there will be more material on which an application could be made. So in this sense, one could say that the removal application is both more difficult and it's also easier than a discretionary grant application. It's more difficult because the threshold is higher, but it is also easier because there are more materials on which the application could be made. So it actually encourages even more disputes. The third factor, and the third difference, of course, is that the court, before removing the executor, would generally give quite a bit of weight to the choice of executor by testator. So this is again highlights the real significance of having a will and a appointed executor, because if you don't have a will and there's no proper estate planning, there's just no testator's intentions to speak of. So this factor just couldn't really come into play at all.
And allow me to interject here.
Yes,
when there's intestacy rules,
yes,
and the spouse or any other family members of the party administering the estate, most of the time they are not professional administrators. They are not aware of the onerous duties that they owe to court and to the beneficiaries in relation to the proper administration of the estate, rendering due and proper account, even though they make an oath to the court that they will administer the estate truthfully and faithfully.
Yes.
And in that respect, actually, administering estate, as you said, is a very onerous task.
Yes.
And even if you are appointed by the will to be the executor, it's not a paid job. Unless you are a professional and you administer the estate with a remuneration clause in the will. Otherwise, you cannot do the job with some expected remuneration from the estate. So actually, in a way, in a thankless job.
Yes.
Why would I do that and subject to the scrutiny or this bill of having your conduct microscopically examined by the court after doing it for a few years without getting paid? In a way, it's very unfair.
Yes. No, definitely. Yes. You'll probably expect the layperson to require quite a lot of professional assistance in administration of the estate. Otherwise, it's very difficult.
That means that if you are an administrator or an executor, and if you have some dispute or quarrel, or disagreement with any of the beneficiaries, the best thing is go to a lawyer.
Yes, no, definitely.
Before it becomes like a full-blown estate dispute.
Yes.
Yeah,
definitely.
Yes.
So now the fourth point going on then, just very quickly, is the conflict of laws point to really, intestacy rules and the different laws that can actually apply. And this is an area that really highlights the need and benefit of actually having a will and having proper estate planning. And it's actually getting more and more common these days, as Alfred has observed, that this is a situation where, I'm talking about foreign nationals that will apply, but it's also apply even to locals who, more and more often we see have assets situated in different, jurisdictions in different places. So, they may have investments in UK, US, or, even other places. And in the absence of a clear stipulation, and a clear choice of law clause, which is usually found in a properly drafted will, one is left to resort to common law rules. And really, in the application and even in determining what rules ought to be applied, there is a lot of uncertainty, a lot of scope for disputes. Now, just as a matter of quick overview, there are two distinctions as set out in the slide. The first distinction, of course, is to understand the difference between the law governing the grant and the law governing the succession and the distribution of the assets. The laws may be different. Law of grant actually relates to what is the law that governs the administration the estate, to manage the estate, and to act as its representative in a particular jurisdiction. The law of succession, on the other hand, refers to how the estate ought to be distributed amongst the beneficiaries and who are entitled to actually obtain distributions from the estate. So law of grant is generally determined by law of domicile. I think that was mentioned by Alfred earlier. That's under Rule 29 of the NCPR. The thing to observe here is that it's quite a factual matter, but it does have a lot of legal principles that intertwine with each other, so it can get quite complicated, especially for older generations. An example is actually a very good example of this is a case which Alfred and I did, which is the case of the estate of Ip.
Oh, okay. Yeah.
Aware.
Oh, that's very interesting
exactly.
case, actually.
So it regards, very briefly, it regards the domicile of a married woman who was first married in Hong Kong and then subsequently married in Macau. And it was then discovered that her Hong Kong marriage was actually never validly dissolved. And the relevance of this is that because she actually died before the 1st of March 2009, which is the commencement date of the domicile ordinance, according to common law, her domicile, which is the domicile of a married woman, actually depended upon the domicile of her husband. So it therefore became necessary to trace the domicile of her first husband, who had actually moved to Singapore and stayed there, and therefore it was then become necessary to obtain evidence of foreign law in Singapore as well, right?
And the horrible part is that that poor woman passed away domicile in Singapore, notwithstanding that she never spent any day there.
Exactly.
It
is quite incomprehensible. Yes. So that is definitely highlights one problem of domicile, and all these problems, of course, actually go away if there is a will in Chinese or English, because under Rule 29, what it says is that regardless of really where the deceased died domicile, if there's a will in Chinese or English that appoints an executor, then that person will actually be able to obtain a grant under Hong Kong law in Hong Kong. And of course, it's important to bear in mind that the grant is quite territorial in nature. So what it means is that a grant in a particular territory or country, that will only be applicable in that particular territory. And the lead case here is, of course, it's a Court of Appeal case in the estate of Nati Rivet, Thai national.
Oh, yeah. That one. Again, very familiar.
Yes, and again, a case which again was involved in. It was very interesting, but I wouldn't say anymore because of the time constraints. Anyway, on the law of succession, of course, that depends on the nature of property. That's where the second distinction you see on the slide actually comes into play, which is immovable versus movable property. Because generally speaking, immovable property it will be governed by the law where the property itself is situated, so the lexitis. Whereas where we talk about movable property, such as chateaus or bank balance, etc., that will be governed by the law of domicile. Right. So, given limited time, I wouldn't go into any more details of the conflict of law issues, but it is safe to say that this is particularly problematic. And in fact, just to give a further flavor of further complications, one issue that often arises, as Alfred was actually just discussing just now, where we talk about multi-jurisdictional estates, is that of tax, right? Succession tax, estate tax, and estate duty. One issue that can arise, of course, is whether assets in the place of domicile or in the principal asset place of the deceased can actually be used to pay for tax liability elsewhere.
Yes, yeah.
So that is actually quite a difficult question. Now, according to Hong Kong law, where the deceased actually died domiciled in Hong Kong and where there's a will, the leading case in this issue is the case in HSBC and Laufer, again, a case that I was involved in. And the key finding is that really ultimately it will be a matter of construing the testator's intentions as set out in the will. Now, that of course applies if there's a will setting out clearly testator's intentions, or at least even if not so clear, at least there's something upon which the court can actually construe. The problem, of course, lies where there is no will and no estate planning at all, because that just becomes very, very uncertain. And the situation as of now, to the best of my understanding, that's actually not resolved. So we don't really know what will happen, especially when we talk about tax law, because tax law are generally not enforceable outside the jurisdiction where it was actually made, right?
On that is a particular regard.
Yes.
Can I just ask, so if let's say there are multi-jurisdictional assets
Yes.
and there are multi-jurisdictional wills.
Yes.
In Hong Kong, in particular, the wills are often drafted without taking into account any of the tax issues.
Yes.
I remember in the old days when there was estate duties,
Yes.
we would often put in clauses to say that the distribution will only be made after paying the estate
Exactly.
duty. And in particular, when there is a particular piece of asset, it may attract higher duty.
Yes.
That we would specify that selling that part of that asset,
Yes.
pay tax, and then distribute. But then nowadays, a lot of time we won't take into account tax.
Yes.
And if there's no mention in the will
Yeah.
that whether the estate should be paid with the tax,
Yeah.
how to ascertain the deceased intention?
Yes, yeah, that's a very good question, because that in fact was the situation in the case of HSBC and Alfred that I was just mentioning. In that case, there wasn't a specific clause that talks about tax in multi-jurisdictions or a very express wording referring specifically to succession tax or succession stamp duty. What there was, however, and which is also present, I think, in a lot of standard properly drafted wills, is there was a clause that whatever payment distribution is actually subject to the payment of testamentary expenses, duty, and liabilities of the estate. So there were this sort of standard clause that deals with expenses, liabilities, etc., etc. And then, of course, in that case, what happened was the distribution that was being made to the beneficiaries. What happened was that it was subject to deduction for all these liabilities, expenses. The estate would be divided into a certain amount of equal shares to be distributed according to a particular schedule. So then one share goes to this, one share goes to that, another share goes to some other beneficiaries, etc. So the court was actually able to construe this subject to payment of expenses and liabilities clause together with the fact that there was this intention to actually make sort of equal sharing amongst the beneficiaries. So to combine these two and then to say that means that there was actually intention. Of course, there was some other factual matters present as well, but the key factors was because there was such wording in the will. Therefore, the testator actually intended for the stamp duty, regardless of the place where the assets are actually situated, to be paid off first before it is distributed amongst beneficiaries. So it's really based on that, a matter of construction of the will.
I think that's highlight the importance of having lawyers who are very familiar with multi-jurisdictional estate planning issues in order to make sure that there are appropriate clauses in place and take into account the potential tax liabilities that may arise for assets outside Hong Kong.
Exactly. So, of course, if one is quite alert to that, and if one actually provides specifically for payment, knowing where the assets are situated, and provide expressly for payment of the succession or the estate duty and taxes in those jurisdictions, then that would make things even clearer, and then the matter wouldn't have to go to court at all. So that would actually be ideal.
And actually, a big burden on the court is to determine the deceased intention.
Exactly.
When we cannot really go down 6 feet under, knock on the casket and ask, what's your intention?
Yes.
Yeah, but that goes down to the importance of having proper record set out when the will is prepared.
Yes.
Because that usually rely on when the deceased intention was to be ascertained.
Yeah.
And I think a lot of time, a lot of people do not have this idea about the importance of taking the proper written note when they're taking instructions before preparing the will, sending the will to the deceased or even his or her family members for approval, explaining the contents of the will properly and make sure that the deceased understand.
Yes.
That will be something that we will talk about.
In fact, yes, that actually leads very nicely to the third part of the topic that we're talking about today, which is the consequences of poor estate planning. So, of course, I know the time, but I think we can just very quickly go through this as well. oftentimes, when we talk about where there is a will, it has, in order for it to be valid and enforceable, there are three main requirements. Of course, firstly, formal validity, i.e., it satisfies the requirements for formal validity under Section 5.1 of the Wills Ordinance. Second requirement is testamentary capacity. Testator must have capacity in making the will. And thirdly, the testator must have knowledge and approval of the content of the will. So in terms of formal validity, that sets out Section 5.1. Again, there are three main points. The will must be in writing. The will must be signed by the testator with intention to signify his approval of the will. And thirdly, it must be attested, meaning that it must be witnessed by someone with intention to witness and to prove that the will was actually signed by the testator and made by the testator. All right. So these problems, of course, these requirements, they usually wouldn't be too much of a problem when we're talking about solicitor's drafted will. But of course, when we're talking about homemade will, right, where a layperson just decides to write something on a piece of paper, and most often one would expect, naturally they wouldn't have much knowledge of this formal validity requirements, and therefore, generally speaking, those requirements will not be complied with. And to cater for such situations, what we have in Section 5.2, the Wills Ordinance, is a saving provision. So what it allows for is that if the court sees a document that embodies the testamentary intentions and is satisfied beyond reasonable doubt that that is actually the testamentary intentions of the deceased, then it can give effect to that particular piece of document despite the formal validity requirements not being satisfied. And of course, just 2 points to note here very quickly. Firstly, the threshold is high. It's very high because there is a lack of formality. And of course, one purpose of formality in the first place was to ensure the certainty of the intentions, to make sure and make clear that that was in fact the will of the testator. And the absence of such formal validity, what replaces it is a high threshold. So the court must actually be satisfied beyond reasonable doubt. The second point to note, of course, is that the document embodying the testamentary intentions, while it must embody testamentary intentions, that need not be the sole purpose of the document. So in fact, one very interesting case where Section 5.2 was actually applied was where it was applied to writings in the deceased diary. Yeah. So in a particular entry, he actually mentioned something about giving a gift or some property to his wife, and the court actually gave effect to that. So even though it was just an entry in a diary, that was sufficient to be a valid will as well.
I remember two cases. One case is that I personally handled is a will that was drafted by the lawyer, but it was never executed. Yeah. The family who tried to probate the will has to produce some contemporaneous document and evidence to show. For example, the will was the draft will was sent to the deceased by WhatsApp. To the deceased for approval, and then they have to produce the whole conversation. But obviously, how to show that it was the deceased who was texting on WhatsApp to the other end, yes, approved. It could be any person, as long as the person will assume the control of the deceased firm. Yeah. And we're talking about beyond reasonable doubt. Yes. That would be a lot of problem. Yeah. And another problem that we have seen is suicide note. I'm dying, I don't love this will anymore, I want my children to inherit my wealth. Is it how to prove that the suicide note was actually is a will containing testamentary wishes? Yes. Yeah, and actually I did handle a case like that, and that case never went to court at the end. Right. Yeah, because it's just too difficult.
Yes. Yeah. Yeah. So these really highlights. I mean, although the route is there, possibility is there, because of the very high threshold, obviously that is unsatisfactory, and would definitely be much more preferable to have a will that's being prepared by a solicitor. And as mentioned, generally speaking, in a solicitor drafted will, formal validity will not be a problem. Having said that, however, just because a will is formally valid doesn't mean that's the end of all disputes and issues. really, as we mentioned, there are two other criteria. So even though the will may satisfy basic requirements, if there's not been proper estate planning and not been proper preparation, this actually leads to even greater uncertainty and disputes. And case in point, which is that in the second point you can see in the slide, is the relatively recent case of estate of Hugill Ip, right? And this is again a leading case that has gone all the way up to the CFA for leave to appeal to the leave committee. It's one of the leading cases concerning testamentary capacity, and sets out really in detail what are the steps that ought to be followed by a solicitor in preparing a will to ensure such capacity is present. And again, in that case, I was representing.
Sorry to interject. You guys have about 5 minutes left.
Okay, thank you, Alex.
I think that 5 minutes actually is very important to go through the Alfred Ip case, because actually it's very that has a significant impact to the practitioner.
Yes, it is. Yes. So now the fact of the case, in that case, I was acting for the eldest brother, right? And to very briefly summarize the facts, the deceased was a successful real estate magnate. He had substantial wealth. By the time in December 2015, his estate was actually of the value exceeding 1.2 billion Hong Kong dollars. He made various wills during his lifetime, and the latest two wills was made in 2002 and 2008, respectively. And at issue in the proceedings was whether the 2008 will, which was prepared and attested by solicitors, was actually valid and enforceable, thereby revoking and trumping all previous wills. And the main ground on which the 2008 will was challenged was the deceased was actually suffering from dementia and therefore lacked capacity when the 2008 will was made. And of course, on the side, there was also a challenge to due execution, because in that case, the eldest son was the one who held the deceased's hand and guided his hand when applying the signature. But the court actually just applying well-established principles held that wasn't a problem, because there was intention by testator. In fact, the testator actually requested the help to guide his hand and sign on the will, according to the evidence of the solicitor. Now, on the main challenge concerning testamentary capacity, what the trial judge actually held was that the deceased was not suffering from any dementia, and that there was therefore no incapacitating factor. So no dementia, no disease of mind, no condition, nothing at all. And taking into account all the evidence as a whole, including rationality of content of the will, interactions with those around the deceased, and the evidence of solicitors preparing the will, and of course taking into account the well-established presumptions, including presumption that a person would have capacity unless proven otherwise, and so on, it was actually found by the trial judge that the deceased was able to and did understand the effect and nature of the 2008 will, and that he therefore had the requisite capacity. Now, when the matter then went on to the Court of Appeal, it was, however, reversed on appeal. And it was reversed on the ground that the trial judge did not sufficiently consider two things, which is whether the deceased had capacity to understand the extent of the assets that were being disposed of, and secondly, the capacity to understand the potential beneficiaries with claims on his assets, i.e. what family members or relatives that he may have. And that the Court of Appeal also held that there was insufficient evidence to support these two criteria, even if these criteria were actually considered by the trial judge. What was surprising, however, was that the Court of Appeal actually did not disturb the finding that the deceased was not suffering from dementia or any condition of the mind, or the finding that the deceased was able to and did understand the effect and the nature of making the 2008 will. So those were not disturbed. The Court of Appeal actually accepted that. What the Court of Appeal did give a lot of weight to, however, was the way the 2008 will was prepared. And the Court of Appeal actually noted that the solicitors failed to make detailed inquiries concerning the extent of the estate, his former wills, his family members, and so on, and that the solicitors actually failed to follow the golden rule of requiring a medical practitioner to certify capacity in cases where testator was old or seriously ill. And the Court of Appeal, through Justice of Appeal Zhou, in particular, laid down a checklist of 10 or more various questions, which is actually taken out from a guide that was prepared by the British Medical Council and the Law Society of England and Wales. And then when the matter went on to CFA Leave Committee, the decision was then affirmed. So where does this decision actually leave us? One striking message which emerges from this decision is that even if a deceased or a testator was not suffering from any mental disease or condition, the will prepared for him by solicitors may still be invalid if there was actually insufficient inquiries from the solicitors preparing the will, or if the proper steps and precaution were not taken. And according to the case, we can see two main guidelines. Those are actually set out in the slide as well. First guideline is, of course, a checklist. It's a checklist of 10 or more questions, and it is used to ascertain various matters, including capacity to understand the effect of the will, capacity to understand the extent of assets, the family members, and difference between the new will being made and the old wills that have been made by the deceased. And the second guideline is in the golden rule. That is relatively well established, set out in the old case, 1975 case of Edward and Adams. Adams, yeah, and of course repeated in many other cases. And basically what it says is that the will must be witnessed and approved by a medical practitioner, as well as the solicitor should actually examine and discuss changes of will being made where we're dealing with a testator who is old or seriously ill. The decision, having said that, and a striking message that actually gives, it actually also gives rise to various uncertainties, right? And three of them can perhaps be highlighted. And the first, of course, is the role for presumptions. Having had this decision by the Court of Appeal confirmed by CFA, it's uncertain now what the role for presumptions are, because previously it used to be well established, both a matter of law and medical fact, that if a person does not suffer from any condition of the mind, then he should be presumed to have capacity. And also, it's also used to be presumed that if a solicitor read out and explained contents of the will and formed the view or impression that the testator actually had capacity, then there had to be very strong evidence to the contrary before the court actually will revoke any finding of capacity. Those, however, have been thrown into some uncertainty. And of course, another uncertainty is what is the difference between capacity to understand the nature and effect of will, in this case, for example, in Al Tim, which was held to be existent, versus capacity to understand extent of assets and the extent to which potential beneficiaries actually have a claim to the estate. Because one would have thought that those are actually more or less just different facets of capacity, but now they're being treated as being separate things altogether. And of course, third uncertainty, and this is perhaps of the greatest practical significance, is the uncertainty as to the impact of the decision on existing wills, right? Because a lot of the wills that have been made now, obviously it was being made before the decision was out, before the checklist was being propounded, and where no such questions were asked. So it's quite unclear, especially because a lot of times when wills are being made, solicitors, they may form the view that, well, in their mind, they don't have reasonable doubt that the testator, deceased, actually had capacity and was healthy and therefore was able to make a will, and therefore they did not go on to comply with whatever further requirements, such as medical practitioner and so on, and then prepare the will. So it's unclear what will then happen to all these wills that actually have been made. But the point really to take home is that in preparing wills these days, one must, of course, be careful to follow checklists and follow the golden rule, so to speak. And very importantly, the message that seems to be, the Court of Appeal was driving home was that the making of a will is not to be treated as a mere formality, but rather as a very serious endeavor that takes a lot of time and effort, and which actually involves multiple personal visits with testator to take his instructions and ascertain his intentions, rather than simply obtaining instructions through family members, which is often the case in Hong Kong these days. So really, I mean, in short, the best advice is to find a lawyer, a competent lawyer who knows his stuff, such as probably the one sitting next to me, Alfred, to prepare the will, because otherwise, it could really get into quite a bit of disputed and uncertain territory.
And don't complain that I'm only charging a couple of thousands for preparing a will.
Exactly.
Yeah,
exactly.
and that was bad. I think our time is running out.
Yes.
I think we should leave some time for anyone who have any questions.
Yes.
All right, thank you so much, Alfred and Kerby, for your insight on the topic about consequences and the importance of poor estate planning, the lack thereof, and also considerations concerning the validity of wills and also the appointment of administrators as well. Yeah, so again, thank you for that. Our LexisNexis account has put out a link. So everyone, if you've enjoyed today's seminar or if you have any comments about today or any other topics you would like to listen to in the future, please, we would appreciate it if you could give us some feedback. And right now we would like to open the floor to anyone with any questions for Alfred and Kerby. So please feel free to turn on your mics and just ask away. Thank you.
While we are waiting for any of the questions that they may have, if there's anyone that we cannot cover all the contents in our webinar today. If there's any question, please feel free to come to us. You know where to find us.
Yeah.
Doesn't seem to be any questions.
I do have one over here. So it's with regards to what Kerby said about the removal of administrators. So the question is, are there any very specific instances or conduct that has led to the removal because the threshold is so high?
Yes, a specific conduct. I think a lot of times these entitling factors the key ones which we've talked about regarding discretionary grants, which is inexplicable diminution of assets, assets being removed and used for personal benefit of the administrator. That would be one key reason. And then of course the second one is where there is conflict of interest, either because there has been certain claims that could be made or certain misconduct that require investigation. But as I mentioned, when we're dealing with removal, because time has actually elapsed and there has been an opportunity for the administrator to actually administer the assets, there are actually, in practice, more factors that are applicable as compared with when we're talking about a discretionary grant situation. So situations where additional factors other than the two factors I've just mentioned include, for example, where there has been failure to account, right? Failure to provide proper accounts upon request. This is a very common factor. A second, often relied upon factor is delay, where the administration has been granted and yet nothing has been done for quite a substantial period of time.
And I think that is the most common.
Delay, yes, definitely amongst the most common, probably if not the most common. And then third, of course, is where there has been impartial, not impartial, but partial treatment. So certain beneficiaries being treated better than others, right? So for example, sometimes there could have been interim distributions made to certain beneficiaries, but not others, or certain property chattels being given to some beneficiaries and not others, and so on. Or even sometimes, administrator himself benefiting from the property without, say, generating income for the benefit of the estate. So these are all additional factors that can actually come into play in practice when we're dealing with removal. Anything? Yeah.
Most common would be living in the deceased home and not accounting for rent.
Exactly.
Especially when in Hong Kong it's too expensive.
Yes.
Thank you. I also see a question in the chat box saying, will a trust set up in Hong Kong assist in smooth succession planning?
Will trust set up in Hong Kong assist in succession planning? Absolutely. That is actually very common in the past when there was estate duty. But now, because of the initial setup fee and the ongoing administration fee, trust has become, like we call it, the rich man's toys. In the sense that a lot of people do have the misconception that only for the million or billionaires that a family trust should be set up. It is actually not true. It very much depends on the benefit of setting up a trust compare with the disadvantage of not having one, and whether it is something that is for the client. I always say, who wants a Ferrari or a Maserati? But if the person can see the benefit of buying it, they have no problem with paying the fees. So the most important is to find a lawyer, get proper advice, see what is the benefit of setting up a trust, and consider whether it is the best for legacy to be passed on throughout generation.
Thank you, Alfred. So now we have one last question from the audience. So if a family trust is established, is estate duty payable when the settlor dies?
If the estate, estate duty we're talking about, then there was quite a while ago. The estate duty was abolished in February 2006. If I remember 2006, it means I was still very young at the time. But then I can only say that if the trust was set up within 7 years prior to the death of the deceased, it may still subject to estate duty, and we are only talking about the Hong Kong context. But in overall, the golden rule is that only those who are in the name of the assets deceased fall into the estate and pass on, and that will attract estate duty. And that is the reason why family trust is set up a lot of time to avoid estate duty.
All right, thank you, Alfred. So I think that would be all of the questions from our end. If anyone has any questions they want to ask out loud, please feel free to do so.
Not very common.
All right, no. Okay, well, in that case, I would like to thank Alfred and Kerby again for hosting today's session, and hopefully it's been insightful for everyone. It surely has been for me as well. So yeah, thank you very much for joining, and please have a good rest of the day. Thank you.
Thank you very much. Bye-bye.
Thank you. Good day.
Good day.